I'm really interested. What reason could there possibly be that the woman would not want to be honest with the child, number one, and the father?
You know, there are some reasons. We'll have other folks testify, but there are situations where women...
Just give me one, and then I know we're out of time.
Okay. If she fears that she will be subject to domestic violence if she discloses
No, I'm
that
sorry.
she had sex
Fearing
with somebody
something's
else.
going to happen is a completely different issue.
During the legislative sessions of 2014 to 2017, attempts were made to change Washington law to allow a man to petition a court for the termination of all legal responsibilities of parentage if DNA evidence shows he is not the genetic father of a child. Among the 7 bills attempted over 4 years, none ultimately passed. But public hearings were held for each bill. Men told their stories, and interesting arguments were presented on both sides. This video shows the strongest arguments for and against the proposals given during those public hearings. In this video, we show highlights from the 3 hearings in 2016 and 2017, the final years this legislation was attempted. In a companion video, we show highlights from the 3 prior hearings in 2014 and 2015. We go now to the Senate Law and Justice Committee for a hearing on a bill sponsored by Senator Pam Roach. First, a neutral staffer to the committee explains the bill.
This bill would be changed to the current 2626 Uniform Parentage Act. There are a number of ways that, under current law, that parentage can be established. What this bill would do would be to allow for someone who has clear and convincing evidence via genetic testing that they are not a biological parent to essentially go into court, rescind an acknowledgement of paternity if they had done that, challenge a presumption of paternity if that were the issue, or contest an adjudication of paternity. And the outcome of that, if proven, would be that the parent would be discharged of all rights and duties of paternity. Their name would be removed from the birth certificate, vacate all previous child support orders, and it would also mean that the father, who has been determined not to be biological father, would not be liable for any unpaid child support or other obligations from the date of this disestablishment order. And there are also issues that are new in this bill, that even though there's an order terminating parent-child relationship, there could still continue to be visitation. The other thing that is new is that it adds a fraud provision, so that in this circumstance, if there was proof of genetic testing, then the father who has been disestablished can not only sue for unpaid child support, for child support paid in the past, but could also conceivably lead to a criminal charge under RCW 9A60030, fraud, Class C felony, for obtaining a signature by deception or duress.
I guess I want to just be clear that I understand. So you have this 2-year window from when you learn of the circumstances. So as a result, you could have a child who's 16 or 17 years old and has been living with the father for his or her entire life, and at that point could be disestablished as the parent.
That's correct. Under current law, there are some provisions and discretion to the court to not permit or not order DNA testing if it's not in the best interest of the child to do so, and that is gone in this bill. You must allow for genetic testing.
This bill eliminates the preference for what's in the best interest of the child, and instead replaces it with what is in the best interest of the plaintiff in this case?
You know, I think that is accurate as far as the specifics. The court now has the ability to apply a best interest of the child standard in determining whether or not to order genetic testing. That discretion of the court to act in the best interest of the child regarding the testing would be gone in the new bill. And as you say, it sort of does shift the focus from what is in the interest of the child to a parent who has been acting as a parent without knowing that their biological DNA does not reflect that they are the actual parent.
I'm sure they would say that they've been defrauded, that they were not the parent, and they're trying to correct an injustice. Let's go to the testimony.
I just wanted to clarify with Senator Darnielle. The bill specifically changes so that the best interest of the child is considered to find the true genetic paternity as soon as possible. So we still do consider the best interest of the children. This has always been about the children. We've worked with legislators and people like David Ward and DSHS over the last year trying to come to some kind of a compromise that would make sense and be fair and to protect the children as well as these men. I have all kinds of legal argument explaining why we wrote the bill that we did, and that's really not what I want to touch base on today, so I'm going to submit that to you, as well as there's about 5 CDs that I pulled from a public disclosure for last year's bill from DSHS that proves a lot of why we made the changes we did. But a perspective that I really want to share with you guys that I have not touched base on is I'm a mother, I'm a woman, and you know, I have a life story that is really kind of hard to tell, and I haven't told you guys this. It has been surrounded by paternity fraud. My first husband, he was also a victim of paternity fraud, and I really didn't know what it was back then. I didn't really pay much attention. He didn't talk much about it. It was kind of a hidden secret. We weren't in the greatest of relationships. There was domestic violence, alcoholism in that marriage, and in a moment of weakness, I cheated on him. Shortly after, I discovered I was pregnant, and I had to do the right thing as a woman and tell him and the other gentleman until we found out the truth of the matter. So I can say definitively as a woman that I have stood in those shoes. There is not a woman that ever comes in here who has committed paternity fraud that comes in and justifies what she has done. But I am here telling you that I've had to make that decision. It's what is in the best interest of my children, and it is not my position as a woman to ever believe that it is right for me to make that decision all by myself.
My name's David Ward. I'm an attorney at Legal Voice, an organization that works to advance women's rights in the Northwest. We have a strong interest in this legislation. We continue, as we have for the past 2 years, to have concerns over this legislation. Fundamentally, we believe our Uniform Parentage Act should be centered on the child and the best interests of the child. And children need stability, they need support, they need to have some certainty in their lives about who their parents are. We actually increased the time limit for challenging paternity in 2011 from 2 years to 4 years, providing a longer period of time than many states do. The bill that we're seeing today, again, would allow paternity challenges at any point in a child's life if genetic testing shows that a man is not a biological father. This year's bill causes us some additional concerns to prior bills. As staff counsel pointed out, this bill would essentially deem a woman to have committed criminal fraud if a man is named on a paternity affidavit and he does not turn out to be the genetic father of the child. It would allow a man to sue a woman for back child support if he turns out not to be the genetic father of a child and she has not disclosed that. There are a lot of reasons why women may not be able to disclose to the genetic father.
I'm really interested. What reason could there possibly be that the woman would not want to be honest with the child, number one, and the father who is not? What kind of reason could you possibly have for being dishonest?
Well,
I really want to know. We're talking about law here.
No,
We're talking about fraud.
I appreciate that, Senator Roach, and there are some reasons we'll have other folks testify, but there are situations where women...
Just give me one, and then I know we're out of time.
Okay, a woman is in a relationship with if she fears that she will be subject to domestic violence if she discloses
I'm
that
sorry.
she had sex with
Fearing
somebody
something's
else.
going to happen is a completely different issue, and I really object it when, Mr. Chairman, when we're talking about one issue and people bring in other things.
Well,
we're talking about the parentage here, and there'll be all kinds of reasons. How about this one? I think I want to have a baby, and I just want to make sure it's taken care of well. So you have sex with 4 different people in 1 week, and you get pregnant. And then you go, who's got the deepest pocket? I don't really want to know who the father is, but I'm going to say the guy with the money. And you know what? That's fraud as fraud comes of it. There's no reason.
Thank you, Senator Roach. We got to move on.
I served in the United States Marine Corps for 4 years before becoming a father in 2010. Being a father is the greatest gift and job on this earth. I am the biological father of a child who was born to a married woman in 2010, who was able to use the presumption of paternity laws to legally kidnap my daughter. I have not seen my child in over 600 days. I'm here today to give testament to the fact that the children at the heart of this issue we call paternity fraud have biological fathers that love them and want nothing more to be in their life. Although the Brandon Jones Act may not fix my particular issue, it is a step in the right direction. For all the biological fathers out there who are now being denied an opportunity to be with their children, this bill will help open the door for that legally to be possible. How can any lawmaker say that it is in the best interest of my daughter, who knew and loved me as her real father for the first 4 years of her life, to be brutally ripped from my arms because of a man-made law? The pain I continue to endure cannot be measured. How do I explain to my 2 little girls at home why their sister is no longer in their life? The Brandon Jones Act is an opportunity to fix the mistakes of the past and set a precedent moving forward. And I'd like to finish with this. The President of these United States stated that fathers need to step up to the plate. How do we step up to the plate if it's being taken away from us?
I'm Charles Shershevsky. I'm here on behalf of the Bar Association. I'm on the Family Law Executive Committee. I used to bring paternity suits. I was a guardian ad litem in a couple hundred cases, including 100 where I was on a state contract for paternity actions. This law is a very significant change. In family law, families are complex. Family law is complex. This law has taken one factor, and that one factor is DNA, and it says that's not only the most important factor, but the only factor that's going to be decided. People do commit fraud, people do lie, people lie all the time in family law, but you have a child that has been raised by a person who thought a person was a father all these years, and this takes that away without the courts being allowed to take that into account.
I think the ultimate thing is that our children should not be surprised. I think they have a right to know who their parents are. Nobody wants that surprise when they turn their Ancestry.com little bit of spittle in. Someone has lied to me. And that should never be the case. The state of Washington should never allow that. We might not like the truth. And you know what? If you have sex with a married woman and have a baby, that's not so good. You got some problems going there. But we can't make the child the person that suffers by having a right taken away from them.
I'm a retired, 100% disabled veteran of Iraq and Afghanistan. Currently, there's an order for me to pay child support for a child who I've proven through DNA evidence is not mine. But this is really about more than just DNA evidence. This is really about more than just paying child support. Under RCW 26.33.350, it specifically states that it's paramount that the accurate medical histories are available to adoptive parents in order to assist the adoptive parents in maximizing the developmental potential of an adopted child. Under the current law on establishing paternity in the state of Washington, the same consideration is not given. In the case of paternity, it seems that money takes precedence over the well-being and maximizing the developmental potential of children.
Rebecca Johnson here on behalf of the Washington Coalition of Sexual Assault Programs. We are a coalition of community programs that serve between 10,000 and 15,000 survivors of sexual assault every single year. And almost a third of Washington women are estimated to have experienced sexual assault at some point in their lifetime. The reason that I give you these stats is to say that this sexual assault and sexual violence is not an isolated incident, and as you're proceeding in this conversation around this bill, we'd ask that you consider the implications for survivors of sexual assault. Under this bill, women face both criminal and potentially civil liability for not disclosing all of their sexual partners, especially for women who may be facing rape, have been sexually assaulted by someone who they fear will harm them if they find out that they're pregnant or if they disclose that that sexual assault happened. There's also the situation that Mr. Ward brought up about being fearful of violence within their primary intimate relationship if they disclose that they were assaulted or, did have a relationship with someone else. We want to make sure that we are considerate and sympathetic to survivors of sexual assault, and we believe that this bill has unintended consequences for women who face sexual violence in their lives.
I can't imagine disclosing sexual partners. That's not the aim of this bill. The aim of this bill is to allow, in my mind anyway, a child to know who the parent would be. We talk a lot about the rights of the parents here, but we're talking about the child in this bill, and I would hope that regardless of who you're representing, that they would have understanding of that. Don't you think the right to know who your parents are is kind of primal?
The issue that I'm raising is around the criminal liability.
Yeah, we're going to fix that. We're going to fix that. Yeah.
As a veteran, I took an oath to defend the Constitution of the United States and the Bill of Rights. I believe that in a case where a parent is fraudulently or mistakenly made responsible for a child that isn't theirs, and there's DNA evidence that proves that they are not the parent of that child, they should not be held responsible. It's pretty common sense. This bill is an attempt to correct an injustice that was made against a citizen of the United States.
Later this same day, the House Judiciary Committee held their own public hearing on HB 2612, an identical bill to the Senate bill just discussed. For this hearing, only the audio recording is available.
House Bill 2612 has to do with disestablishing parentage and associated rights and responsibilities if genetic testing demonstrates that a man is not the child's genetic parent.
If you prove the DNA, you shouldn't have to pay, and that's really the principle behind this. And if DNA is good enough for criminal prosecutions, particularly to exonerate someone, it shouldn't be different in any sort of a civil action, especially to establish paternity. One of the big problems that I have seen with this is tremendously affecting veteran populations because there's wrongfully established paternity, and particularly because of the transitory nature of veterans, this is hurting other families as well. There are other families that are being impacted by wrongfully established paternity and other children that are being less provided for because of this. So I would hope that this year we can figure out some solution to this and help us to, I think, restore justice in this matter.
I'm here in support of the Brandon Jones Act to stop paternity fraud in Washington State. The heart of the matter here really is the children. I can't stress that enough. I'm a mother of 3. I love my children dearly. I love the child that is not the biological child of my husband. I cared for her myself for 5 years, and it's really important that we find some kind of justice for those children to be able to have an avenue in which they can know their genetic parents. I think that it's a fundamental right for the children as well as the fathers.
There are many things I would like to be the face of. Paternity fraud was never at the top of my list. As I explained to this body last session, I'm currently ordered to pay child support for a child who is not mine, who has an ongoing relationship with his biological father, and at one point the child and his father cohabitated. I'm still required to pay. Not because there's not a desire to change that, but because the law says there's nothing that I can do to change it. However, this is about much more than paying child support. This is about doing what is right for the children of Washington State. When a child is a victim of paternity fraud, he or she is put at great risk because not only is half of their medical history omitted, but it is wholly incorrect in cases where the man who thinks he is the biological father gives his full medical history.
My name is David Ward. I'm an attorney at Legal Voice, an organization that works to advance women's rights in the Northwest. Now, a man can challenge his paternity for up to 4 years after his parentage is legally established. We support that as striking the proper balance here for all the interests that are involved. We do believe the most important interest in these cases must be, of course, the child. That's been the touchstone of our family laws for many years. The best interest of the child is the primary consideration. Genetic testing is a relatively new phenomenon. It's important, and it does help to establish parentage. But we've recognized in this state for many years that genetics is not the only thing that makes a person a parent. That acting as a parent on a day-to-day basis and the parent-child bond that's formed by doing that is essential to a child. A child does not really care who their genetic parent is. They care who's there for them day by day and acting as their parent, and losing those relationships could be very critical.
What this does is takes one law that you guys decide that the best interest of the children is knowing who the biological father is, and that outweighs everything else. That outweighs the relationship that a child has with a father. That outweighs any other significant fact. This takes away from the courts, takes away from the guardians, deciding what's in the best interest of the children.
Rebecca Johnson here today on behalf of the Washington Coalition of Sexual Assault Programs. We're here in opposition to this bill in part because of the complications and impact that this may have on victims of sexual assault. The bill creates criminal liability for a woman who does not tell her husband or partner every other sexual partner that she has had, and also creates the civil liability for back payment of child support. There are a number of reasons why a woman who becomes pregnant may not feel that she can disclose all of those partners. The criminal liability and the potential civil liability, unfortunately, we believe would put a woman in a position where she may see her choices as being limited because she fears the repercussions of sharing and being public with an experience of sexual assault. So we would ask that you really think about those consequences to survivors of sexual assault. It is unfortunately something that is not isolated. It happens to many, many women, and we want to make sure that we are protective of and thinking of those women as we proceed.
I'm looking at the bill right now, and direct me to the section where it indicates that a woman has to disclose her sexual partners to...
Can you pull that up, David?
It's not written into the statute, but it does say, again, the import here is if a woman does not disclose that she's had sex with another man who signs and a man signs a paternity affidavit, and genetic testing later shows that the man who signed the paternity affidavit was not the genetic father, the bill does say that in those cases, an acknowledgement of paternity shall be deemed to have been executed on the basis of material mistake of fact or fraud perpetrated by the child's natural mother pursuant to our criminal fraud statutes. So if that's not the intent of the legislature, that a woman should be obliged before a man signs a paternity affidavit to disclose that she's had sex with another man during the probable time of conception, that would be great to write it into the law explicitly, but that is a concern that we have based on the drafting of the statute.
Well, I think that's quite a leap.
I mean, it's not saying that you'd have to disclose every sexual partner you've had in your life, but I mean, the import of this bill is that if a man is signing a paternity affidavit, the obligation is on the woman to tell the man, as well as anyone else she might have been having sex with during the probable time of conception, that they may be fathers too. So it would essentially say you are committing fraud in signing a paternity affidavit, which both the mother and the man acknowledging paternity have to sign, if you don't basically reveal that there could be another person who could be the genetic father of the child.
For the fine lady, totally agree with you. Don't want any woman who's been a victim of sexual assault to be re-victimized. To the two gentlemen, you kept referencing parents and how it's so very important for children to be raised in the emotional needs for both parents. But I don't understand your nexus with this bill. Why cannot we prove who the parents are, and if you are not the parent, then you are no longer responsible to pay for the child? Help me understand what point you were trying to make.
Using the term parent, let me throw in psychological, biological. There are many children who have psychological parents who aren't their biological parents, and the children don't know it. The children probably don't care. This statute doesn't allow a judge to say, this is the psychological parent. You have been the father for this child for 5 years, 10 years, whatever it happens to be, and I'm not going to allow genetic testing or not going to admit genetic testing to take that relationship away from the child. That is what I see that this law would do.
So if I've been psychologically parenting this child, I may have a deep desire to continue to be a psychological parent. Mrs. Doubtfire,
yes,
shows that correlation. They want to continue to be part of that child's life. But I think what we're saying here, that I should no longer have to be financially responsible if, in fact, I am not the biological parent of the child. And there's
Correct.
A difference there, I think. Are we disagreeing on that?
As far as I can tell, I don't think, from the way I read this, there's really any enforceable rights for me, if I'm the psychological parent, not the biological parent, to still have a relationship with that child. And there's certainly no right in that child to the father. I mean, the psychological father can walk away any time. And that's what is taken away from the courts, taken away from the guardians by this statute. I understand the position. Clearly, I understand fraud. I understand that. I may disagree with them a little on whether somebody has a reason to commit fraud, because I'm not sure that there is.
The following year, 2017, the Senate Law and Justice Committee held a hearing on a bill that had some similarities and some differences compared to the 2016 bills. Notably, this was the first time the prime sponsor was a member of the Democratic Party, Senator Christine Rolfes.
Senate Bill 5461 concerns the termination of all legal obligations of paternity and child support if genetic testing shows by clear and convincing evidence that a man is not the genetic father of a child. Genetic testing is presumed to be in the best interest of the child. A court may not deny genetic testing if a presumed father did not know that he was not the genetic father. There are differences between this bill, Senate Bill 5461, and the bill that came before this committee last year. In last year's bill, an order disestablishing a man as the father must vacate all previous orders of child support. And in the testimony from last year, there was concern raised over the effect of vacating previous orders and whether that would make the state liable for previously paid child support. Senate Bill 5461 does not require previous orders to be vacated, but rather states that the petitioner found not to be the genetic father is relieved from future obligations of paternity and child support. As for unpaid child support that is owed, a court must extinguish all or any part of an existing arrearage. unpaid child support on terms that are just. Also, in last year's bill, a petitioner could request the court to grant visitation rights to continue even after the termination of the parent-child relationship. That language is removed. Senate Bill 5461 keeps language from last year's bill stating that genetic testing is presumed to be in the best interests of the child, but it adds language that the presumption is subject to rebuttal. And finally, a new section is added to Senate Bill 5461 that requires the Division of Child Support to track and report to the legislature the number of cases where courts set aside a judgment of paternity and support.
So under the Uniform Act, if you have a signed acknowledgement, the only way to do a denial of parentage is if you've identified who the actual father is so that the child is not left without two parents. Am I understanding correctly that this allows a denial of parentage without establishing who the actual or the biological father is?
It creates an alternative. So the existing law still stays in effect that if you have someone else who is willing to acknowledge parentage, you can submit a valid denial. And that is one way, but
now you could have a denial without actually having another parent.
Using genetic testing and petitioning the court.
I bring this bill before you because there's a fundamental unfairness inherent in the way the legal system is set up regarding fathers. And I have spent a decade in politics defending mothers and helping to reunite families and to do everything that I can to support families in this state. And under the current legal system, there are rare but numerous instances where the presumed father or the man in the relationship just is not being treated fairly. And so I completely understand Senator Peterson's concerns. I am completely supportive of doing this in a way that is not harmful to children. But I believe that there are circumstances where the child would not be harmed by the disestablishment because there was no relationship to start with, but where another family may be being harmed and where the man is being treated unfairly. So I would really appreciate this committee digging into this problem and seeing whether there is a way to resolve it so that the judicial system is working in the best interest of every citizen of the state.
What do you envision vis-a-vis a child who is presumed that this person is their father, has had a significant relationship with him, and who would like to have a continued relationship with that person? So does the child have any actionable status here where they would be able to see this person again?
Part of the language that Melissa and I worked through was leaving some flexibility for the court to be able to make that decision of what's in the child's best interest.
Washington places a high premium on the needs and interests of children. Indeed, our entire family law structure centers around children's interests and needs. That is why I'm here today to urge you to reject SB 5461. It would harm children in our state. It could authorize substantial lawsuits against mothers, and it will fundamentally upset how parentage is managed in our state. Our Uniform Parentage Act was written carefully and updated as recently as 2011 to balance the interests of children and their parents. But the strong emphasis is putting the children's needs first. This bill would destroy the careful balance that the legislature reached in 2011, and the people who will be harmed are the children. It would allow a man who has been a child's legal parent to terminate his responsibilities at any time during the child's life. Imagine if you were a child who'd been parented for 6, 7, 12 years, and all of a sudden you're told he's not your father anymore, and you're not going to see him again. We recognize that families are complicated and messy, and many of us come from complicated and messy families. But one thing we learn when we come from that background is that you have to think of the children first. It is not in the best interest of children to reduce parentage to a question of genetics. A child doesn't care about genetics. A child cares about his parents and about remaining safe and in contact with the parents he has. Please reject SB 5461.
I'm here today to testify in opposition to this bill. We still feel that this bill will harm women, especially those who have experienced sexual violence. This bill is problematic for sexual assault victims who were assaulted in the context of their relationship by their partner and their spouse, and in the context where the perpetrator is someone other than their partner and the spouse. This bill lacks an understanding about the dynamics of sexual violence and related trauma. Rape is a violent crime that can result in pregnancy. In fact, rape-related pregnancy is approximately 32,000 women annually. And sexual violence in relationships and marriage is also not uncommon. As a result of this bill, rape victims could face liability if they do not tell their husband or partner that they were raped and a child was conceived. So what if a woman is raped and does not want to tell her husband? If she becomes pregnant and doesn't tell her husband that the rapist could be the genetic father, is she doing something wrong? What if she was threatened? What if her family was threatened if she told? For a rape victim, whether in a relationship with the named parent or not at the time of the rape, there are many reasons why she may not tell. Reasons for not sharing that they were raped can include, but are not limited to, fear of not being believed, fear of being blamed for the assault, that they may be at risk from harm from that partner or spouse or from the rapist, that they were threatened, that they were drugged, that they are suffering adverse trauma symptoms, that they didn't believe that they could have gotten pregnant from the assault given the frequency and or their use of birth control. There are many other more reasons. We ask you to think about sexual assault victims in the context of this law and vote no.
Signing in favor but not wishing to testify, Brandon Jones, Eric Johnson, opposed, Pamela Crone, in favor, Kyle Paskowitz, Jonathan Infrade, Stephen Woodley, and Al Acosta.
Watch the companion video to this one, which shows highlights of how things played out during the 3 hearings in 2014 and 2015 prior to the hearings in this video.